everyone, welcome to Lucid Mains program by Neo IAS. Today we'll be dealing section 377 of Indian Penal Code. This is how we go about with the topic today. First we'll be discussing why section 377 is in use, what is section 377, timeline of events, grounds of unconstitutionality, difficulties faced by LGBTQ community, highlights of the Supreme Court verdict, international case studies, concerns and challenges, and the way forward. Why in news? The Supreme Court pronounced its verdict on Navjit Singh Johar and others versus Union of India, which seek decriminalization of consensual gay sex under section 377 of the IPC. The court has partially struck down section 377 of IPC and decriminalized the consensual gay sex, saying that the right to love is an individual's choice. So, what is section 377 of Indian Penal Code? Whoever voluntarily has carnal intercourse against the order of nature with any man, woman or animal shall be punished with imprisonment for life or with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. So simply put, this section 377, which came into effect in 1861, deems sexual intercourse against the order of nature as punishable with imprisonment of between 10 years and a life sentence along with a fine. So this section, for easier understanding, can be divided into three parts. First is, it criminalizes homosexuality. It criminalizes certain acts between heterosexuals, that is between a man and a woman, like anal or oral sex, which are against the order of nature. Also, it criminalizes sexual activities between humans and animals. Now, talking about the timeline of events, in 1861, there was introduction of section 377 by the British, which found sexual activities between members of the same sex was against the order of the nature. In 2001, the NAS Foundation, a New Delhi-based NGO that works in the field of HIV/AIDS prevention, challenged the section in the Delhi High Court. They filed a lawsuit to allow homosexual relations between consenting adults. But in 2003, Delhi High Court dismissed the petition, saying that the body had no standing in the matter. But the foundation appealed the dismissal to the Supreme Court, which instructed the Delhi High Court to reconsider the case. So in 2009, the Delhi High Court, in a landmark decision, decriminalized homosexuality among consenting adults, holding it in violation of Article 14, 15 and 21 of the Constitution of India. But in 2012, the Supreme Court overturns the Delhi High Court after finding it legally unsustainable. The Supreme Court then recommended that the Parliament should address the matter because only they had the power to amend the existing laws. In 2014, in NALSA versus Union of India, the NALSA means National Legal Services Authority of India. So in that case, the Supreme Court granted personhood to transgenders. In 2015, Shashi Tharoor introduced a private member's bill to decriminalize homosexuality, but the Lok Sabha voted against it. So in 2016, 5 petitioners moved Supreme Court over section 377. In 2017, there was another case, Justin Puttaswamy versus Union of India. In this case, the Supreme Court held that the privacy is a fundamental right, and it was observed that sexual orientation is an essential attribute of privacy. In 2018, a 5-judge constitutional bench led by Chief Justice of India, Deepak Misra, begins hearing on section 377, and in September, the Supreme Court decriminalizes homosexuality. Since the recriminalization of homosexuality in 2013, the Supreme Court has dealt with the issue of gender rights in 2 key cases. That is, in 2014 case, NALSA versus Union of India and Justice Puttaswamy versus Union of India. These 2 cases have taken a more progressive approach towards gender rights and the rights of LGBTQ community. But these cases did not directly touch upon the issue of section 377 as it was not the issue before the court. Now talking about the grounds of unconstitutionality, the section 377, according to the petitioners, violates the following fundamental rights. It infringes the guarantee of equality in Article 14, the promise against discrimination in Article 15, the right to free expression contained in Article 19, and the pledges of human dignity and privacy inherited in Article 21. And the pledges of human dignity and privacy inherited in Article 21. Now let's see some of the difficulties faced by the LGBTQ community. Homosexuality is treated as a disease or mental illness. There are corrective rapes and honor killings with this regard. There is inhibition to go for medical aid due to prejudices. Depression is high among members of this LGBTQ community, and one of the prime reasons for it is the failure to lead a normal life. Because of family and societal pressures, these members are forced to marry opposite sex, leading to bisexuality and other mental trauma. Jobs and in turn financial security is denied to people on the basis of their sexual orientation. Although prosecution under Section 377 is not common, police use the law to harass and intimidate LGBTQ community. Now let's see the highlights of the Supreme Court verdict. The Supreme Court termed sexual orientation as a biological phenomenon and said that any discrimination on the grounds of sexual orientation is violative of fundamental rights. It also stated that individuals have sovereignty over their bodies and their intimacy in privacy is a matter of their choice. The state has no right to control private lives of the members of LGBTQ community, and also the denial of the right to sexual orientation was the same as denying the right to privacy. The court also found that Section 377 of IPC is used as a weapon to harass members of the community, resulting in discrimination. The LGBTQ community enjoys the same rights as other citizens under the Constitution. The 5-judge bench of the Supreme Court partly struck down Section 377 and decriminalized consensual sex between two adults of any gender in a private space, as they are neither harmful nor contagious to the society. However, other aspects of Section 377 dealing with unnatural sex and animals and children remain in force. Any kind of sexual activity with animals and children shall remain a penal offence. Now talking about the international case studies, in 2007, Nepal legalized homosexuality, and the new constitution of Nepal also gives many rights to the LGBTQ community. In 2015, Ireland legalized same-sex marriages. It is the first country to allow same-sex marriage at a national level by popular vote. In 2015, the US Supreme Court ruled that same-sex marriages are legal. France, UK, Canada, US, Australia and Brazil have decriminalized homosexuality, while countries like Nigeria, Iran, Saudi Arabia, Afghanistan, Qatar, Pakistan, etc. still criminalizes homosexuality. The European Court of Human Rights have observed that homosexuality cannot be criminalized owing to public opinion. Now coming to concerns and challenges, the judgment which decriminalized homosexuality marks the end of the first leg of the battle for social legitimacy by the LGBTQ community. However, other issues like same-sex marriage, inheritance of property, civil rights, etc. are yet to receive legal sanctions. Another concern is that discrimination, prejudice and humiliation are unlikely to disappear. It will require massive effort to communicate the implications of the judgment and the change to vast sections who are grown and live by standards which are very different. Another point is that the Section 377 relates to sexual relations between consenting adults. The current law on rape is inadequate to address non-consensual sex between same-sex individuals. The same follow through when it comes to sexual harassment. Another point of concern is that the Supreme Court's trump of demonstrating the power of law to build a better society lies the failure of its people. It shows that we the people are willing to outsource the task of challenging oppressive traditions to our courts rather than engaging with them as a polity. Now talking about the way forward, Various programs and educative campaigns are to be carried out to reduce and finally eliminate the stigma against homosexuality. Periodic sensitization and awareness training be given to government officials about the plight of the members of the LGBTQ community. Another point is rape law reforms for male survivors. There is no law to protect adult male victims of sexual assault, so the parliament needs to fill these gaps in the law. Ensure rights of vulnerable, especially those who may be vulnerable and may be easily tricked into unacceptable behavior by another individual with a different sexual orientation, must be protected. That is, like helpless children and women are not to be a victim of such behavior. Another point is ensure complete equality. A holistic protection of fundamental rights will be justly guaranteed when larger issues of legalizing same-sex marriages, inheritance, adoption, and reservation in employment are widely covered in its ambit. We already saw under the difficulties faced by the minority community that they shows inhibition to go for medical aid due to prejudices. So this judgment against Section 377 should be treated as a marker of evolution of mental health rights. For this, a greater understanding of practices in therapy rooted in equity and sensitivity to the marginalized is required. Transformative constitutionalism. Dynamic constitutional interpretation allows for the progressive realization of rights as societies evolve. That's all with regard to this topic. Thank you for watching.